Deported before justice? Canada's rising trend of removal while appeals are still pending. Welcome back to Canada Chronicles. Today, we're diving into a growing issue in Canada's immigration system, one that has sparked debates among legal experts, government officials, and advocacy groups alike. What happens when someone is deported before they've had a fair chance to appeal? With deportations increasing at an unprecedented rate, many individuals are being removed while their legal cases remain unresolved. Is this necessary enforcement to maintain an orderly system, or is it a flawed process that denies due process to those affected? This video will break down how deportations work, why some individuals are removed before their appeals are reviewed, and what this means for Canada's immigration policies. But that's not all. Stick around until the end, where we'll explore real-life cases of individuals who faced removal before justice could be served. If you care about immigration policies, human rights, or simply staying informed, you won't want to miss this. Make sure to subscribe and turn on notifications so you never miss an update from Canada Chronicles. Alright, let's get started. Rising deportations in Canada. A system under scrutiny. Canada's immigration system has long been considered one of the most structured in the world. However, a growing trend in deportations, particularly removals while appeals are still pending, has raised concerns. In 2024 alone, the Canada Border Services Agency reported 7,300 deportations, a 95% increase from 2022. While Canada has strict procedures to ensure fairness in the immigration process, the sharp rise in removals has prompted debates about whether the system is functioning as intended. The key question is whether individuals are being deported before they have fully exercised their legal rights. Some argue that swift deportations maintain order and credibility in the system. Others worry that removals before appeals are concluded could lead to irreversible consequences. To understand this issue, let's break down how the deportation process works, the legal pathways for appeal, and why some individuals are removed before a final decision is made. How deportations work in Canada. Deportations follow a structured legal process, but complexities within the system can create confusion and unintended consequences. The type of removal order issued determines how and when a person must leave Canada. Departure orders. A departure order requires an individual to leave Canada within 30 days and confirm their departure with border officials. Failure to comply automatically escalates the order to a deportation order, carrying more severe consequences. Exclusion orders. An exclusion order bans re-entry to Canada for 1 year. If the exclusion is due to misrepresentation, the ban extends to 5 years. Deportation orders. A deportation order is the most serious removal order, permanently barring an individual from returning to Canada unless they obtain an authorization to return to Canada, ARC. In theory, individuals have the right to challenge these decisions, but in practice, many are deported before their appeals are fully reviewed, leading to significant concerns about due process. The right to appeal. A process that doesn't always prevent removal. Canada provides legal avenues for individuals to challenge their removal orders. The Immigration Appeal Division of the Immigration and Refugee Board is responsible for hearing most appeals. However, not all appeals automatically prevent deportation. Some individuals can still be removed from Canada even if their appeal is active. This bureaucratic complexity forces individuals to navigate multiple layers of legal processes while trying to remain in the country legally. To file an appeal, individuals must submit a notice of appeal within 30 days of receiving their removal order. However, delays in processing mean some cases take months or even years to be heard. If authorities choose to move forward with a removal before the appeal is reviewed, the individual may have no choice but to leave before their case is reconsidered. Some attempt to apply for a stay of removal, which temporarily halts deportation until the appeal is resolved. However, stays of removal are not automatic and are granted based on the strength of the individual's case, the likelihood of success on appeal, whether deportation would cause irreparable harm. If a stay is not granted, removal proceedings continue even if the appeal remains unresolved. A major challenge in this process is the lack of clear guidelines on how the Canada Border Services Agency determines when to proceed with deportations while appeals are pending. While some cases see removals delayed until a final decision is made, others are fast-tracked without much explanation, leaving individuals and their legal representatives uncertain about their chances of remaining in Canada. This lack of consistency raises concerns about fairness, as two individuals with similar cases may experience very different outcomes based on how their files are prioritized. Legal experts have called for more transparency in the decision-making process, arguing that clearer rules could help prevent unnecessary removals and ensure that those with valid claims receive a fair chance to have their cases fully heard before being forced to leave. Without a uniform approach, the deportation system continues to create uncertainty for thousands of individuals facing removal orders, making it difficult for them to plan for their future while waiting for their appeals to be processed. Establishing clearer criteria for when deportations should be delayed could help restore trust in the system and prevent individuals from being unjustly removed before their cases are fully reviewed. Why are some individuals deported while their appeal is still pending? Many wonder why Canada would deport someone who has an active appeal. There are a few key reasons. Not all appeals automatically stop removal. Certain appeals do not grant an automatic stay of removal, allowing authorities to proceed with deportation even while a case is under review. While some individuals may qualify for a stay of removal, others do not, meaning they could be deported before their appeal is heard. Government's focus on deportation enforcement. The Canadian government has increased funding to process deportations more efficiently, allocating $30.5 million over 3 years. The goal is to reduce backlogs and remove individuals with no legal status quickly. Authorities argue that removing individuals ineligible for status as soon as possible prevents the system from being overburdened, ensuring that resources are allocated to those with the strongest cases. Processing delays in immigration appeals. Due to an overwhelming increase in applications, the Immigration and Refugee Board faces significant backlogs. Since there is no legal requirement for border officials to wait for an appeal decision, deportations sometimes occur before appeals are fully reviewed. Critics argue that this approach compromises due process, as individuals may have valid claims but are removed before they have the opportunity to present key evidence. International pressures on Canada's immigration system. Global migration trends have added pressure on Canada's ability to process applications efficiently. With more people seeking entry into the country for economic, humanitarian, or family reunification reasons, authorities are increasingly focused on preventing backlogs and discouraging fraudulent claims. This has led to a stricter enforcement approach, ensuring that cases deemed inadmissible or ineligible do not remain in the system indefinitely. While this policy helps maintain order and efficiency, it can also result in hasty removals that fail to consider new or evolving legal arguments in appeal cases. Limited resources and the push for efficiency. An additional factor influencing deportations during pending appeals is the limited resources available to accommodate individuals waiting for their cases to be heard. Canada's immigration detention facilities and temporary housing programs often operate at or near full capacity, making it difficult for officials to justify delaying removals for individuals with unresolved appeals. In some cases, the government prioritizes removal over prolonged stays in detention or temporary housing as a cost-saving measure. While this approach reduces strain on government resources, critics argue that it prioritizes efficiency over fairness, potentially leading to premature deportations before individuals have exhausted their legal options. These factors combined create a system where some individuals are removed before they have fully exercised their legal rights. While officials emphasize the need to uphold immigration laws and prevent unnecessary delays, legal experts and advocates continue to call for greater transparency and fairness in the deportation process. Thank you for staying with us this far. We appreciate your time and hope you're finding this information valuable. Now, let's look at real-life cases where individuals were deported before their appeals were resolved, and the consequences they faced. Real-life cases of deportations before appeals were resolved. Colombian refugee claimant. A Colombian national applied for refugee status, fearing persecution in their home country. Their application was denied, but they filed an appeal citing new evidence of threats from armed groups. Before the appeal was reviewed, they were deported. Reports indicate that after being sent back, they were kidnapped and have not been seen since. Nigerian student seeking work permit. A Nigerian student overstayed their visa but had applied for a postgraduate work permit. While awaiting a decision, they received a removal order. Despite securing a full-time job offer, border authorities enforced the deportation before the application was processed. These cases highlight the difficulties individuals face when removals occur before their legal process concludes. Potential solutions to ensure fairness in the system. Experts have proposed several reforms to prevent unjust removals while maintaining an efficient system. 1. Automatic stay of removal for all appeals. Ensuring that no one is deported before their appeal is fully reviewed. 2. Faster processing times for appeals. Addressing case backlogs to reduce delays in reviewing deportation appeals. 3. More transparency in deportation decisions. Requiring clear public reporting on when and why deportations occur. 4. Expanding legal aid for asylum seekers. Improving access to immigration lawyers to ensure stronger legal representation. Balancing fairness and enforcement. Deporting individuals while their appeals are still pending is a complex challenge for Canada's immigration system. Some argue efficient removals are necessary, while others emphasize due process must be protected. What do you think? Should Canada enforce deportations more strictly, or should every appeal be fully reviewed before removal? Comment below and let us know. If you found this video informative, hit the like button, subscribe to Canada Chronicles, and turn on notifications so you never miss an update. Thanks for watching, and we'll see you in the next video.